Assalamualaikum warahmatullahi wabarakatuh. My name is Arif Hamdan and I'm going to be presenting on my case, which is BK Fleet Management Sdn Bhd and Stanson Marketing Sdn Bhd. So I'm going to be talking about the background facts of the case, the issues that came up, the arguments from the counsels, and the decision and ratio from the judge, and also analyzing some parts of the case. So firstly, in the background facts, BK Fleet Management is a company that supplies trucks and provides services like maintenance for those trucks. Stanson Marketing is a company that's involved in sales and distribution of bakery goods. Between them, they entered into 4 agreements, all the same, which is that BK is to provide trucks and maintenance for those trucks, and Stanson has to pay a monthly sum to them. However, Stanson failed to keep up the monthly payments. So here's a timeline of the events that happened. On 25th November, BK issued a notice of demand, and again on 21st February 2012. Then 12th April 2012, Stanson obtained a restraining order to prevent legal proceedings from happening against them. Then sometime later, when that restraining order was no longer in effect, on 15th of January the next year, BK initiated a suit and made a statement of claims against Stanson, seeking an order for Stanson to pay their unpaid dues back to BK as well as for the trucks. Stanson made a counterclaim, which is for the registration cards for those trucks. Now, the case was brought to the High Court in Penang, where the judge of the High Court dismissed claims from both parties because the agreements were considered as void ab initio and were therefore unenforceable as per Section 24 of the Contracts Act. He said that the parties registered the truck under Stanson's name, the defendant's name, to circumvent the requirement of having an A carrier's license for the trucks that is said to be required under Section 14(2)(a) of the Commercial Vehicle Licensing Board Act 1987. This all basically means that the plaintiffs were originally supposed to get an A license before they can rent out those trucks, but instead they registered those trucks under the defendant's name. If BK had to go get an A license, it would only increase the monthly payments that the defendants would have to make under the agreement. So that's why they just registered the trucks under the defendants' names. The judge held that this defeats the purpose of Section 14 of the CVLB Act and was against public policy. On top of that, the plaintiffs were unable to obtain any relief under Section 66 of the Contracts Act, since both parties were aware of the unlawful purpose of the agreement. That is where we are today. The plaintiff made an appeal to the Court of Appeal, and now the issue is whether the agreements were enforceable or not. So first of all, Section 24 deals with what considerations are lawful. All considerations are lawful unless it fits any of these criteria. It's also worth looking at Section 66, where when an agreement is discovered to be void or when the contract becomes void, any person who receives any agreement under that contract is bound to restore it or to make compensation for it to the person from whom he received it. From the appellant submission, BK, previously the plaintiff, said that the agreements did not contravene any provisions in the CVLB Act. This is because the respondent is the rightful registered owner of the trucks. The appellant is just the beneficial owner of the trucks. He also said that it's common in hire purchase agreements for the hirer to hire out the vehicle to any hiree so that that hiree can use it to carry his own goods while operating under his own C permit. This is standard in any hire purchase agreements you can find today. And they said that Section 24 should not be applicable. And even if the void is found, and even if the agreement is found to be void, the appellant could still get salvation under Section 66. The respondent didn't make any submission because he did not appear during the hearing in the Court of Appeal, and so the court struck out his notice of cross appeal. So the Court of Appeal decided to dismiss the appellant's appeal with no cause, and they affirmed the decision of the learned trial judge. Now we're going to look at the reasons why. So to explain it this way, License A is needed if you want to rent out a vehicle, a commercial vehicle. License C is needed if you want to use a commercial vehicle to carry your own goods. Now, the appellant is supposed to obtain an A license in order for him to be allowed to rent out the vehicle to the respondent. He knew of this requirement but said that trying to fulfill this requirement would only increase the monthly rental of the trucks. That's why they instead registered the trucks under the defendant's name, so they can skip that part entirely. It was made to circumvent that requirement of obtaining the A license. This was seen as to defeat the provisions of the CBRB Act. This is similar to the case of Sajjan Singh and Sardar Ali, where Sardar Ali was a lorry driver. He wants to get a lorry on his own so he can do his own transportation, but he has no chance of getting a haulage permit at the time. Sajjan Singh, on the other hand, is a hauler and has every chance to get a haulage permit. So they both agreed that Sajjan Singh will get a second-hand lorry and would go get a haulage permit and register those two things under his own name, but not all the time. It was intended for those things to belong to Sardar Ali and used by him on his own account. Now, this agreement was seen as against the regulation of the Road and Transport Ordinance 1949 and had amounted to an illegality. What happened to the haulage permit and what happened to the truck? The same thing as our case right now. The Court of Appeal referred to the same case where it said that, in the words of Lord Eldon, let the estate lies where it falls. So that means currently the trucks are with the respondent, so that is where the trucks will remain. So the respondent gets to keep the trucks. Now the appellant is claiming under Section 66, which is that even if the agreement was void, this section should be brought up. However, both parties entered into the agreement fully aware of the nature of that agreement and the ramifications and the effects that would have, that is circumventing the earlier section. Besides SEMA, Sawmill Co., Sembahan, and Asia Holdings, they interpreted Section 66, which is the section therefore enacts in statutory form that contract is illegal in itself and is void and unenforceable. So their agreement was already void, so it's unenforceable, so they can't bring up Section 66. Ip Moy and Chu Chin Chua also commented on Section 66 that an agreement discovered to be void does not mean that the contract is void on discovery or void because of the discovery of the illegality. It means what it says. And the Court of Appeal also agreed that the four arrangements were caught on Section 24, which is they were against public policy and were against a law. Citing Murah Mahawasa, Sdn Bhd and Datuk Shazil SK, the provisions of Section 24 contracts I referred to earlier are explicit statutory injunctions. The statute provides expressly that considerations of objects referred in paragraphs A through D, A through E, in Section 24 shall be unlawful and the agreement which ensues shall be unlawful and void. What's the stance taken by courts in dealing with illegal contracts? In dealing with illegal contracts, there was settled in Limca B and Rule 40's properties, where it said that courts have always set their face against illegality in any contract. It is very well settled that the courts take judicial notice of such illegality and refuse to enforce the contract. And so the Court of Appeal dismissed the appellant's appeal and affirmed the decision of the 11th High Court judge. Now, to analyze some dissenting judgment from Mailing JCA, one of the dissenting judge from the case. She said that in Section 14, there was no any wording to say that there is a prohibition. Section 14 merely says that it was a requirement. There was no prohibition. That was merely that Section 14 sought to provide the requirement and possession of a valid carry license. To this, I would argue that the purpose of Section 14 is to state that you must have those licenses and it's a condition that must be fulfilled. In the current case, how can the appellants rent out the trucks if they don't have the license? It's directly against Section 14. Another point that she made is that if the court were to allow the appellant's claim, it would not be opposed to public policy. Now, for this, I will argue that if the appellant's claim was allowed, then people can see that Section 14, the requirement for the A license, is useless if you can do what these parties just did. They can completely circumvent all the requirement of getting a license A. And furthermore, in their agreement, the appellants agreed to buy back the trucks from Stanson for a price range between 1 ringgit to 100 ringgit after they're done renting them. So that makes Section 14 completely useless and the requirement of getting an A license optional. That's not how you want people to view the law. Responsible businesses must abide by the law and not take shortcuts around it. And so that's all for me. Thank you very much. Assalamualaikum.